right, I want to go ahead and jump on part two. Okay, motion to strike. A motion to strike is a request when one of the parties wants something removed from the court records. This motion is usually requested when the record contains information or language that is not admissible evidence. A party may request a motion to strike if the language being removed from the record is redundant, vague, scandalous, immaterial, or impertinent. Furthermore, a party in a case can request that a vague statement be removed from the court records, from the record, to be replaced with a statement that is more sufficient and clear. Okay, I may say I've never used, I haven't seen one in a court case before. Probably, I don't look up a whole lot of people's cases all the time anyway, but I do understand where this was coming from. Like sometimes if somebody can use any statement that may not, I think it was pretty clear. I don't want to go in and try to explain my own version of what I'm thinking, but it already makes it very clear what somebody's putting in there. If it's not admissible evidence, that would be the main reason I would use a motion to strike for the most part. I don't get involved in a whole lot of drama anyway. So if somebody puts something in a court case and it's not it's information, it's an informational language that's not admissible evidence, then I would do a motion to strike. I could see somebody doing that. But anyway, let's go on to the next one. Motion for summary judgment. A motion for summary judgment is perhaps the most frequently made motion. Okay, we've heard of this one a lot. A lot of us have heard of this one. While not always available in all cases, the motion for summary judgment is made before the trial begins. Okay, the motion asks the judge to make a decision on a case without going to trial. Such motion can only occur if none of the facts of the case are in dispute. Thus, all that needs is to be made to be decided is a final ruling on the case. So there's pretty much no argument whatsoever. We got all the evidence we need. The opposing party is not even disputing it. So let's just get a summary judgment. That's pretty much what it says. If available, a motion for summary judgment can save both plenty of time and money. While a motion for summary judgment and motion to dismiss are often confused with one another, they are not the same thing. The motion to dismiss results in a case being thrown out altogether and no verdict can be issued. Without a motion, I never thought about that. That's true. With a motion for summary judgment, however, the court and both parties agree that there is a legal issue that the court can rule on. For a summary judgment to be issued, I'm gonna stop right there. For a summary judgment to be issued, there can be no dispute about the material facts of the case, and the party filing the motion must be entitled to, as a matter of law, to a judgment. A summary judgment is most often used when the time has ran out on a discovery process. Okay, meaning that neither side can gather any more evidence to help their case. That's pretty much it there. I'm gonna stop right there, y'all. The motion for, as you see right here, motion. Well, I'm only 4 minutes into this video. I can go to one more. Let's see. Motion for summary judgment. So we already get what that is. There's no fight whatsoever. All the evidence has been presented in the case. There's no rebuttal. There's no, that's how a lot of y'all can get a. I wonder if they're finding there being a difference between a default judgment and a summary judgment. Well, default judgment would pretty much result from someone that's not even fighting at all. Like they didn't file an answer or anything. They didn't show up or anything. They're not even at the table. They just kind of let it happen. But anyway, let's go to one more. Okay. Motion for a direct verdict. Okay, this is my first time reading up on one of these here. A motion for a direct verdict. Another motion that shares features with a motion for a summary judgment and a motion to dismiss. A motion for a direct verdict is one whereby one party, in this case, the defense, ask the court to end the case. The motion for a direct verdict is made by the defense after the prosecution has already rested its case. This motion argues that the prosecution has failed to prove its case, and that because of that, the defense does not need to present any evidence. That's pretty. I never thought about that one. Okay, it's pretty good. A motion for a direct verdict is essentially the same as asking the court to acquit the defendant because there is not a strong enough case to convict him or her. Okay, that makes good sense. I never thought about this motion right here. So I just learned something just as I was reading this with y'all. So we all learn this together. If you never heard of a direct verdict, a motion for a direct verdict. So I never heard of that before. So that's a pretty good one. Let's see. Let me see what time we got here. Yeah, I'm gonna go ahead and end it, y'all. It says 6 minutes in. I think I did pretty well. Y'all know I be having these long ass videos, so I don't think I should go one more. Just end it right here. I'll end it right here, and I'll go because I got another part to come anyway. I got more to go. So if you haven't liked and subscribed already, y'all go ahead and like and subscribe. And I will see y'all in part 3 of these motions. What we call these motions? The 13 was how many motions? Anyway, I'll see y'all in the next video. Emeralds signing out.